Good morning. We're here with Scott Heisey with Stewart Title. Scott, what do you do for Stewart Title? Can you tell us what your role is?
Sure, absolutely. And I'm happy to be here this morning. I'm a senior title officer for Stewart Title Company, amongst 7 other title officers for Northern California.
What exactly do you do as the senior title officer?
That's a great question. So what we typically do is we look at the risk of any transaction related to, what's going on. So escrow will get the transaction. If they have an issue or a problem, they'll elevate it to us on the title side if it's going to be a policy situation, right? So keep in mind that the policy covers the insured being either a lender or an owner in this case, and we set the terms of the policy and underwrite the liability. So if a transaction, let's say, is $5 million, it would come to me and I would look at it and underwrite that and make sure that our risk or mitigated risk is within tolerances.
So it's just not, you're not just specific to probate and trust transactions. You actually kind of oversee everything.
Everything.
Wow.
And we underwrite for all of California. So even if there was a transaction in Southern California, I can underwrite that. But yeah, it's usually predicated on a liability or risk amount.
Okay.
But then something that is excessive risk or outside the box, probate, elder abuse, things like that, to where we look at questions, potential fraud and forgery would come to us. And then we would work with attorneys or the parties to ferret it out.
Well, kind of segueing into that, with the recent transaction that we just kind of went through, kind of similar to what you're saying. Mm-hmm. We kind of had some things that we thought could have been fraud. What kind of things do you look for then flag in those types of situations? Like, Ron, do you want to tell them?
I mean, essentially when you're working with transactions, what is a red flag for something that you would say, yeah, this is potential fraud? It could be elder abuse. It could be a title issue, something like that. So let's just start with elder abuse. Elder abuse, what is a big potential red flag?
Great question. All right. So let's go back in time a little bit, because we're really talking about the baby boomers, right? And keep in mind that the baby boomers as a demographic are living longer than everybody else that came before them.
Right.
Right. So in this case, my dad's 95, still sharp, doing great. But his parents, my grandparents, died in their 60s, and they died of generally old age at that point, right? So here it is. We have this demographic of people that are going up in age. Well, what's the side effect from them living longer? Generally, it's incapacity. It's mental issues,
Cognitive decline.
Cognitive decline. That's a great way to say it. And then what happens is that the fraudsters come out to capitalize on that. And the reason for this is that the baby boomers as a demographic own more equitable real estate than the rest of the other demographics combined. So here's this pool of money sitting there that's available to people who wish to tap into it, whether legitimately or nefariously.
And kind of going into that, like nefariously, is it self-serving deeds, or what kind of catches your eye in regards to the fraud? Is it not going through a title or escrow company and then trying to sell, just to get the deed recorded and then trying to sell the property? So kind of, what? Sure.
That's a great question. It's kind of the number one thing. So whenever we see deeds that were not handled by title companies in a chain of title, we call them uninsured deeds, right? So we question that because they kind of fall outside the bounds of a transaction. They're kind of out of the blue, suddenly interject. So I'm going to use you two as the example. You're an elderly couple. Let's say you pass away, Rod, and you are, the only remaining spouse in this case. And generally, if you really dig in and look at a chain of title, I can get a feel for how old you are, right? Let's say you bought the property in 1960. All right, so I got a pretty good idea of where you're at. Or maybe you're not even alive right now and somebody's trying to attack your estate. But let's look at it from that standpoint. You own the property, let's say it's in a trust, and suddenly it pops out of the trust and it goes to an individual. Why? That's a questionable thing, right? You go, because it's in a trust, the trust should remain for the remainder of your life and then be distributed to the people listed within the trust itself. So why was the trust circumvented? Question mark, red flag in essence, right? So that's where we start that process.
Can we go back a little bit and just for Northern California, explain the fact that there is escrow portion and then there's a title portion, right? And they're different than like Southern California where they're kind of mixed together.
Well, it's actually the opposite.
Okay, my apologies.
So no, it's all good. So in Southern California, title and escrow are separate. You have separate escrow companies and separate title companies. The escrow companies are the clients of the title company itself.
Okay.
So a title company rep or business development officer generally is soliciting independent escrow companies for their business. The unfortunate part of that is, and I almost hate to say this on camera, is that there's far more fraud and forgery in Southern California than there is in Northern California. And the reason is because we're combined up here. I interact with my escrow officers in all of Northern California much more closely. And even though they are technically my client because the revenue is created by them, we're under one company umbrella. So I'm servicing the escrow people in hopes of closing a transaction and driving revenue to the bottom line. But keep in mind, we're in a checks and balances situation, right? I'm checking what they're doing. They're checking what I'm doing. So we keep everybody safe.
Kind of bringing us back to the situation that we just had where we had two people that were on title there was a probate, there was a guardianship, and there was a trust.
Yep.
And I don't think all documents had been provided at a certain point, but we came up to a place where it looked like there had been some fraud, and we were kind of trying to reach out and see if, what we needed in terms of clarification. And it was a comfort letter. So what kind of documents would you need for something like this? And what do you guys look for as far as red flags?
Yeah, that's a great question, Jennifer, is because that transaction unto itself was unusual.
Yeah.
Right? We had 3 children involved, in essence, for the sake of simplicity, 2 separate fathers, right? And then we had a woman who I believe had ended her own life. So we have that situation to where we have tragedy, some separation. You look at this as, on its face, it looked troublesome. Let's start with that. And this woman left one child to one sister and set up a trust. When this thing went through this probate, it was set up in a trust for a minor child. And then the other sister was also taking care of the 2 other children from the other relationship in a guardianship. So you had 2 sisters representing 3 minors in this case who were supposed to benefit from the sale of the property. The proceeds from that sale were for their benefit. Well, okay, first we had to establish that all of that was legitimately set up. We knew what their attempt was. We knew what their goal was. Did they get it there all the way? Not generally to the satisfaction of a lot of title companies. But we also have to look at the circumstances and how do we serve the greater good in a situation? Is it perfect? No. Can we deal with it? Potentially. So back to risk mitigation that you and I had talked about off camera is what is insurance? And I'm going to say this out loud. You already heard it. But insurance of any kind, car insurance, life insurance, title insurance, is the exchange of money for inherent risk, right? So the inherent risk of that came to me and I looked at it and mitigated down through conversation with you guys. Communication with attorneys and agents and everybody involved, principals even, is key to get the story to find out, is it legit? People who are working nefariously will avoid those conversations.
Right. And that's kind of one of the things that we had red flag because the one sister was not being fully communicating with us as agents. She was kind of going to here and there. And so the information wasn't getting to everyone that needed to get to in the proper way. So it did kind of look like there was some things that were not on the up and up.
True. And also keep in mind, just because somebody's odd doesn't make them criminal, right? And we have to look at that as well. But we have to establish it, right? To go, is somebody just, reclusive, maybe a little weird type of thing? Okay, we can deal with that once we establish or identify it and go, they just, and I think in this case, she liked driving the bus.
Yes.
Didn't like being questioned. But anyway, we got there, right? And the reason we got there was literally communication through you guys. So that helps a lot. But in my industry, and I hate to say it, and I don't know, I'm looking at the paper of the questions there, is that title people in the industry don't like picking up the phone. They generally won't communicate. So it's very easy to say, no, I don't like the way this one looks and reject it. And I don't think that's very wise because the story fills in the blanks.
That's very commendable, actually, now that you called us, because it could have been rejected and no one would have answered. It didn't have to answer at the point where it's just, let's say, underwritten, but then they rejected the underwritten portion of the deed. But you actually gave us a call, which is fantastic. And we did work through the process of actually communicating together. So now that I think about it, that's huge. So thank you for that.
Yeah. And
Because I mean, ultimately you could have said no and the transaction would have stopped there.
yeah. But what's very interesting is that, again, back to the industry itself, most title people are not held accountable to rejecting something. The word no comes out of their mouth far too easily. I'll probably get killed by my counterparts in the industry here. But there's no ramification. You know what I'm saying? Is that they don't have to look you guys in the eyes.
Well, that's not true. And that's one of the reasons I love Stewart Title, because I'm in the office all the time.
Yeah. So, and I've been doing this for 42 years. And I found that historically it's always been that way. And that has always bothered me. Keep in mind what we do for a living, right? Title and escrow and the entire process is literally customer service based. You use Stewart Title because you like the customer service that is provided by the escrow officer and ultimately the entire program. At the end of a transaction is when we issue a policy. The policy might be our product, but everything leading to that end is customer service.
Yes, which I have to say, Stewart Title has great customer service.
I love this. It's a Stewart Title commercial now.
Yeah, it is.
Well, let's go back to square one.
Sure.
What are some of the documents in order to close a probate transaction that Stewart Title looks for? Like some of the basic documents.
Yeah.
If we're just saying, hey, we're sending you these deeds, and obviously this is going to need to go through probate. What are the final documents that would satisfy escrow, in other words, to close the transaction?
Yeah, so I'll kind of break it down to the few most simple or mandatory documents that come through a probate process, right? So initially, you want the letters of testamentary, right? You want to know who's in charge of the estate, who's been legitimized as the person handling that transaction or the estate of the descendant. And what's very interesting about that is that, so if you have a will, your testate, right? And generally a will appoint an executor of the will. Jennifer, in this case, I'm going to just use you as the example. I do a will, I appoint you as my executor because let's say you're my daughter in this case. All right, but what if I don't have a will? Still going to probate. The will itself is just a template that helps the courts determine what my wishes were. Can it be contested? Sure. Let's say you're my executor. I leave everything to you, but Rod's not mentioned in there whatsoever, and he's my son, and he's absolutely just persona non grata. And so you get your day in court. You show up and go, time out. This doesn't make sense. And Jennifer's like, but he left everything to me. Dad loved me most. We run into this a lot, right? But let's go back to Rod. Rod goes, well, the will was executed 30 days before Dad died. Dad was in his late 90s when he passed away. Was my capacity in check? You know what I'm saying? You could question capacity. So these are the things that we have to worry about. These are the things that the courts have to worry about. So let's go back to the will. So whether you have a will or don't have a will, you're going into probate.
Correct.
Right? Again, the will just gives the template. The validity of the will is also being checked by the courts.
Correct.
Right? So we go through that process. All right. So the next step is you're the executor of this situation. You're appointed the head of the estate, the administrator or executor of the estate through the letters of testamentary. So title company now has somebody who we can vest through who's now driving the bus. If you are with full authority to sell the property, you can enter into contract to sell the property. Great. The next thing a title company generally wants is the notice of proposed action. Make sure that all the heirs were notified and that they've responded or failed to respond in the 15-day timeline. That is a tacit yes. All right. So now you've pretty much waived your rights to complain, Rod. So you're sort of out at that point. Does that not mean you can file legal action? No, it doesn't mean that, because we end up with that roadblock quite often where you may have missed your opportunity, but now you're going to hit it in a different court. So we have to step back and wait for those things to see themselves through. All right.
Now, what happens if they have a will? They're going through probate. You're going to leave the house to me, but for some reason, there's somebody else on title as joint tenants. So, or like you had put me on the deed, as a joint tenant, or, does then that take Rod's rights all away? Do you take that into consideration
Sure.
for not having to go through a probate for the home itself?
Sure. So let's change the scenario a little bit. We're dad and daughter in this case, right? And I've owned the property for a long period of time. I realize that I will not live another 20 years. So I do a deed for myself to you and I as joint tenants. When I pass away, the right of joint tenancy kicks in. We avoid probate. You get the property. Can he contest that? Maybe. But the problem is that if I created a joint tenancy last week and died this week, right? Red flags are flying. Again, my capacity is now questionable. The other part is that if I circumvented Rod as an heir, why did I do that? Right? So again, and this would be an uninsured deed of which we'd go back and go, wait a minute, how do we validate the deed? Well, usually in a deed that's recorded without the assistance of a title company or a logical transaction, uninsured deed, we go to the grantor and say, fill out this affidavit saying this was your intention. But in the case that we talked about, I'm dead. So you're like, great, you have control of the property. I want to sell the property. It's a huge timeout, right? Why? Because I'm going to go back to that baby boomer thing. They're getting older, but we're seeing much more incapacity. And we're seeing people now manipulating them into giving their property away. So what if you were nefarious in this case? A nefarious daughter who's now circumvented her brother out of 50% of the property. Do I want to then do a transaction and ensure a new buyer that you legitimately had 100%? No. So, but how could I legitimize that? Well, let's say we know that you and Rod are the only heirs to my property anyway. Maybe I can get a hold of him. I'll talk to Rod and say, you okay with your sister getting this 100%? And you go, yeah, she took care of dad. I'm great. Fantastic. Maybe we get a quick claim deed from you just to kick it over and legitimize it as a potential option. So are there ways to fix these things? Sure. But what's that take? A lot of communication, just like we went through on that other one.
So we have another one that consists of multiple properties, and they've been in the family for generations. And the mother, kind of what you're just talking about, the mother had gotten older, and the brother and sister used the power of attorney to put the deed in their names. And then it just kind of went on that way for years. And then the sister ended up passing away. And then the brother, she was still on the deeds to a couple of the properties, and the brother ended up passing away. And so then they were left to a son who was trying to take it, now having to go through probate. But it just opened up a whole can of worms because title is like, we're not doing that at all. They're self-serving deeds. What happens in that situation? Are we at a quiet title, or do you take those types of things into consideration?
Yeah. So great question. So I'm going to rephrase it a little bit, and then we'll come back to exactly the scenario you talked about. If I were to give either of you a power of attorney, that does not include the right to deed the property to yourself. Unfortunately, we know through many generations, or just people, not everybody understands this, right? They go, wow, things are going sideways for me. I'll give you a power of attorney. And I'll give you a really clear example of this. San Jose, California, a few years ago, I did a transaction where mom was ill. So she gave her eldest daughter the power of attorney. The daughter then deeded the property to herself and her siblings. She included everybody in this. So there was no nefarious means here. And the power of attorney did include the right to convey real estate.
I read on power of attorney, it's very clear on what you can and cannot do.
Correct.
And you have to check a box that says, I allow or whoever the power of attorney is to sell my property.
Correct. Right. So it included real estate. The problem is that it was self-serving as to her use, to her receiving a portion of that property. So it was legitimate to her two other siblings. So what she did convey was 2/3 of a property, leaving 1/3 of the property that needed to be potentially probated, right? So it wasn't nefarious. It was just being naive. The other thing we run into is people using powers of attorney post-death. Once the person passes away, the power of attorney is null and void. Do people know that? No. So is it fraud? No, it's being naive. Is it, was it legal? No. Is it a voidable transaction? Yes. But the problem is that when does it get to me as an underwriter or a title officer to review this? Unfortunately, at the 11th hour of every transaction. So then I have to hold up and say, this doesn't work and this is why. And I'll kind of mention back to something you and I talked about earlier, was that people think if something records at the recorder's office, it's now gospel. It must be good. And that is the general thought process of people who are not in this industry. And we have to go back and let them know that the recorder's office does not scrutinize documents for their validity in relation to a chain of title. It just has to meet the statutory format of recording, not legitimacy.
That's great.
Yeah,
that's huge because going back to the power of attorney, I think a lot of the times when we meet with clients, they're always happy to give me the power of attorney document because, I've got the power of attorney. But they don't realize that document does null and void once that person is deceased. Mm-hmm. I think that's very huge because people don't really know that. We just went on another. Again, we went to go talk to a potential client, and he's like, "Well, I've got this power of attorney, and I could have all this power." And I'm like, "You don't really understand. Once this person has been deceased, dies, this is null and void."
Yeah.
And so it's great that you clarify that.
Yeah, and it's interesting is that in setting up a trust, I have 3 boys, and we set up our trust. But in this industry, I realize that people that set up their trust don't normally sit their kids down and let them know what the obligations are. As a matter of fact, many people probably don't understand because they have their attorney set it up, but they thought once it was set up that it's all good and they don't need to understand the terms so much. So we sat down, again, being in the industry, sat down the 3 boys and said, okay, this is how it works. This is who's responsible the moment we die. This is what we want done. It's all good. They understand it now to the best of their knowledge. Now, again, if we live another 20, 30 years out, they're going to forget everything we told them. So we're going to have to kind of periodically go through this. But I kind of want to go back to your question specifically because we sidestepped off of that and you said self-serving deeds. Well, executing deeds using a power of attorney for self-serving purposes is void. Those are just voidable transfers. And we go back to, we look at it, was it malicious? Now, if it wasn't malicious, doesn't make it doable, right? But it kind of changes the tempo of the thought process where they weren't doing something for their own personal gain or trying to take something away from one sibling to the other. So then you had mentioned earlier in a conversation that this took place a very long time ago. Okay, so if we're talking 50s, 60s, 70s, well, those deeds may be considered seasoned, if we put it that way, and actually to the camera, seasoned. So we'll do it like that, is that if no one's contested these, can we let it fly? And again, let's go back to the exchange of money for risk. Nobody's contested it. Everybody's okay with it. The assessor's office didn't flag it as self-serving because generally they're a checkpoint and they're much better than they used to be, by the way. And so can we get through it? Potentially, case by case. And again, I'm going to go back to the communication situation. Give me the story. Let's dig into it a bit. Talk to the remaining principals. What was the intent, right? And then can we work with it? And so, yeah, I mean, as long as we can establish many times that it wasn't nefarious, we have everybody on board. If there was people that were inadvertently left out, can we get them to surrender consent back, either quitclaim deed or written consent back? So there's your communication thing again. You're going to hear it ad nauseum through the rest of this conversation.
No, and we love that because that's huge. Communication, what they say, communication is key. So just by looking at it, like say, case by case and timeframes and whatnot makes a huge difference in terms of, like in this case, the property is not worth what it would take to have to do a quiet title action.
Right.
It's $12,000 versus, $20,000 for a quiet title. So
And no attorney will touch it because there's no money in it for them.
Yeah.
They can't charge $400 or $500 an hour to cure something that's only worth a few grand.
Yeah.
Right. So that makes sense too. And those properties can become lame ducks. And then, as you mentioned even earlier in the conversation, do the people just walk away and let it fall to the sale of the state under defaulted taxes? Well, that seems to be kind of a crime unto itself.
Yes.
Right? Is it necessary?
Can you clarify for me when an uninsured deed affidavit is used and then also when a quiet title would be used? When would you use? I know they're two separate documents.
Sure.
So can you just clarify?
Yeah. So uninsured deed, again, it's an industry thing that was created because, I'll even take you back a little bit. Once people had access to Google, they kind of avoided title people, right? Where they'd go in and ask questions at the local title company, which was much more like Ace Hardware, the mom and pop stores, right? And they'd go in for help and get customer service help on that. And so it always kind of kept the chain of title square. Well, now people want convenience, just like going to Starbucks on every corner. So what do? They Google it. How do I deed this? Google it. And of course, the cardinal sin is they read the first 4 lines and become instant experts, download the PDF of the deed, and away you go. But they don't understand that when they go to sell something, even if they did it correctly, the title company is going to do the timeout and try to legitimize that. Let's go back to Rod, you deed to Jennifer, right? Without a title company thing, Jennifer, you go to sell it. I want to go back to Rod and substantiate his signature on that to make sure his intent is to convey it.
What happens if I'm dead?
Well, then we're looking at, again, if it looks nefarious, and Jennifer, you don't look nefarious, but if that looks nefarious and it's all about timing, again, you executed that deed and died in a short time later, I have to question 2 things. 1, was it you? Were you competent? Was a power of attorney used? Because we get that a lot too. And so we start to dig in. But let's say you're still alive. So we go back to you and ask you for an affidavit, right? And you're like, sure, yeah, I meant Jennifer to have that. Fantastic. We just head square out. But you asked about quiet title, right? Quiet title is a totally different thing to where generally if title is so destroyed, is so messed up that we can't make heads or tails out of it, or we look at the records and we even look at what the assessor's doing, right? Because the assessor has their own conveyance department and they're trying to figure it out. We go, timeout. Who thinks they have it? And I get this a lot in Santa Cruz County, generally the Santa Cruz Mountains for some reason, because everybody does their own thing. And we go, okay, Bob Smith thinks he has it. He thinks he got it through inheritance from here. Who got it from this? Who got it from this? And we go back, let's say we're going back 30 years. But the last good title is in like 1971. And we go, okay, you're going to have to quiet title this to eliminate all the potential errors between 71 and the present. It's just to clear the way. Let the courts have the say and give everybody a chance to weigh in. If they don't weigh in, then it becomes a default judgment, right? And then they get it by default. And that's okay. And we run into that quite a bit. You mentioned adverse possession, right?
Yeah, we have another one that the folks bought a piece of property with a house on it.
Yeah.
And then there was a lot, right next door. And they said, we'll sell this lot to you on a handshake deal. You just pay the taxes and it's yours. And so they've used it for over 30 plus years, paid all the taxes. I mean, the tax bill literally goes to their address, and now, they're coming to this point where the deed was never changed over into their names. And both people who are entitled to this lot they're both gone.
Yeah.
They're deceased. So now we're kind of, what do we do? Are we doing adverse possession? Do we have to do probates? Like, it's a huge can of worms.
And it's kind of funny is because we can't ensure the good neighbor policy, back to your handshake.
Yeah.
Right? We know the intent based on the story, right? So we go back to look at this thing and, back to adverse possession. Well, generally adverse possession falls into place if you've paid the property taxes and maintenance and a bunch of other stuff for a period of 5 years or more. We don't pursue the adverse possession. That's on the client and the owners themselves to get that order, which again is akin to a quiet title action, to where the courts deem that, well, no one's attacked title. You've been paying the taxes. Therefore, you are the assumed owner because no one's thwarted that. And that's great. And I'll retell the story that I told you a little earlier today. I did have a transaction where there was 2 condominium units next door to each other. In one unit, this gentleman had a heart attack and the emergency services showed up and carted him out to the hospital, and no one locked the door on the way out, and he never came home. He passed away. And the neighbor waited a while, waiting for somebody to show up to the house, which they didn't. She went in, changed the locks, started paying the property taxes, and rented out the property. And just quietly claimed it as her own, waiting for somebody to show up. They did not. And at the moment of that 5-year span, she contacted an attorney, pursued adverse possession. By the way, the punchline, I didn't tell you this, it was a condominium in San Francisco worth more than $2 million. So pretty good kind of fallback for her.
Is that morally correct to do? Jeez, Louise.
If nobody shows up, apparently he had nobody supporting him, right? So he didn't have any children or anybody who cared enough to be there. So that's the sad aspect of it.
And she may have taken care of him throughout the years
Maybe.
of knowing him as a neighbor. And, I mean, not that that makes it okay, but I mean, maybe there was a story that we didn't know.
But what's
behind
interesting is that she didn't do anything illegal in the end. Maybe the initial trespassing, which isn't our concern, but she legitimized it through the court process. So these things happen, right? And this is the stuff I get involved in. And it is interesting. And again, I'll speak to attorneys. I do speak to attorneys all day long. And they'll call me and say, is what I'm doing okay? Will you insure something if I do it this way? And sometimes it's yes, and sometimes it's no, let's tweak it. Let's do these things. So yeah, I mean, it's been a great career, I can tell you, but it has changed drastically in the last 10 years. First 30 years did not prepare me for the last 10.
Can I bring us back to trusts? So when a person has a trust, say they're a married couple, one passes away, what do you need in regards if they don't file an affidavit of death for on title? What do you need? Is that something that you're going to ask for right away, or
Generally, that's a fantastic question because it is probably the thing that comes up most often.
Let's I didn't mean to interrupt, but let's give the basic context of what a trust is.
Sure.
Let's do that first, where you can all the components of what a good trust should be, and then we can go to that. Because I don't know if everyone understands that there's got to be a grantor or a trustor, successor trustee, and then a trust. Well, actually, the trustee, successor trustee, so all that good stuff.
Yeah. So a trust in layman's terms would be a probate done soup to nuts while you're still alive. This way you avoid probate. You've essentially done the probate work, right? So instead of an executor being appointed via the will, it's a successor trustee. If you're not able to act, and I'll use you too. Let's say you're husband and wife, you set up a trust, right? So you got the Rod and Jennifer trust, and you're both trustees of that trust. Well, generally, let's say, Rod, you pass away. The terms of the trust would state that if he passes away, you're the remaining trustee. You can act as sole trustee. This is very much more of the vanilla black and white situation. So in other trusts, if one of you pass away, sometimes it appoints a co-successor trustee, generally a child. And I see these because if a trust is created at an age where you're elderly, and the thought process is that if one of you passes away, the remainder is going to need some help. So there's an automatic appointment in there. Other times, if you're younger, like you guys are, you pass away, you can act solely. If you pass away, there's an appointed successor trustee. And I'll go back to my own trust, 3 children, right? Here's the cardinal sin of most people, baby boomers included, is that they don't want to upset the apple cart. So they appoint all of their children as co-successor trustees. Well, the worst part about that is that if those children did not get along in life, they're not going to get along in your death.
I've actually got one I'm dealing with right
There
now
you
that
go.
I'm going through.
So yeah, if anybody's listening, you're setting up your trust, don't appoint everybody as co-successor trustees. So in my case, we appointed my youngest son as the successor trustee. Not that the other 2 were not worthy. They absolutely were, but they don't live local enough. They're both out of different states. So for the youngest one is the closest, to us geographically. And so it was the logical thing. But we did tell the other 2, what do you guys think? And they're like, yeah, we trust him. That's great. Now, I hope that holds true when we're dead.
Yeah.
But the other part is we're dead. What do we care? So we'll kind of put it in those terms. So yes, a trust is a probate done soup to nuts. So that's what we have. But here's another thing that I'm running into. And
I never looked at it that way, actually.
Yeah.
A trust is a probate essentially in itself, right? So you just kind
That's the reason
It's
you
avoiding having to pay the courts and the states for everything.
Yeah, it's kind of an upfront thing, and it's a way to avoid probate, right? So therefore, it is kind of a probate. Now, if you're a younger couple, let's say, and you're doing that, make sure younger people, their lives change rather rapidly. 3 to 5 years, there's something that's changed, right? So you should update that trust. Older people, generally it's stable at that point. You don't need to update it or do amendments. But the one thing, and I really want to mention this because it ties back into the power of attorney situation. Generally, a trust that's set up does have a coattail of a durable power of attorney attached to it. Keep in mind that durable power of attorney is to handle things outside the assets of the trust. And that becomes blurred a bit because...
The bank account or other properties outside the trust?
Well, not so much properties, but personal things, right?
Tangible items.
Yeah, medical needs, things like that. So, and this is, again, more of a baby boomer thing, and I'm going to constantly use you two as the examples here, but I set up a trust. You're my successor trustee of the trust. You're named first, right? And that is kind of a baby boomer thing. The other part is that you're the person that I've appointed as my durable power of attorney because you're my caregiver. You take care of me. Doctor's appointments, medicine, maybe bank things, right? Anything that's outside the trust itself. Remember, the trust is a safe that's holding all our assets type of thing. So when I become incapacitated, right, it triggers you to act as successor trustee. The problem is that I live with you. You and I have 100% correspondence all the time. So I become incapacitated. You think, well, I need to take over. You contact a real estate agent. You go into a listing agreement, but you have zero authority to do that. But you don't know it. You're just assuming it because you've done everything to date, right? Then I get that and go, Jennifer, she can't do any of this. It really falls back to Rod as successor trustee because the real property is contained in the trust. And I get that conflict. Now, what if you two didn't get along? Okay, then now we could have a fight because you feel you have the authority to do so.
As a durable power of
attorney.
attorney.
Hard work. That's what people look at it.
That's what happens.
I'm entitled because I've been taking care of
There you go.
Yes.
Right. So that we run into that quite a bit. And again, it's a baby boomer thing to always appoint the eldest son as in charge of things. That is evolving as like your demographics changing, much more pragmatic about what they're doing and not going into these normalized default processes. So, but keep that in mind because I get this a lot where, it's in a trust, but they want to use a power of attorney. I'm like, time out. 1 in 100 trusts will allow for a power of attorney to be used. The second part of that is that is the person appointed as attorney in fact the same person as the successor trustee? Let's pull it back into the terms of the trust and do a legitimate transaction using the correct authority process. I had an attorney call me, an estate planning attorney call me and say, hey, I've got a client, I set up her trust, but she lives in another country. And she wants to sell the property, but she doesn't have anybody here. She wants to give me power of attorney to sell her property. I said, but you set up her trust. He goes, yeah. I said, did you put in a provision for a power of attorney? He goes, no. I said, so you, attorney, tell me how this is going to work. And he goes, oh man, good point. I said, so I won't tell you the workaround. We did find a workaround on it because there are things that can be done. But there was a clause in the trust itself that said you could employ people. And so we coattailed off of that. So she was actually employing him to do something to make it work. And again, we legitimize this stuff to make sure there's no nefarious means or fraud and forgery involved. Mm-hmm. So that's how we did that.
A couple has a trust and one passes away. What are you looking for in that? Just as far as, do you need the whole trust? The trust certification page showing that person is the trustee, and if they're both still alive, do you need those items
that's
too,
or did great question.
What do they sign in order to prove?
That's a fantastic question because when a prelim comes out, the preliminary report that we issue on a property, and it shows the property is in a trust, there's usually an exception or a clause that goes in there that says we require a copy of the trust. But if both of you are able to act and you're fine, we don't need that. We don't need to dig into your personal lives to that extent. And we would accept a trust certification, which is you're fine to us that you're acting within the terms of the trust itself.
Now,
That's all
how
you
do you
gotta
get that? Who provides that? Do I provide that if it's my trust? Do you guys have that?
Either way,
Stewart Title to provide to us?
Escrow has our own form for that, and you can fill that out. But if you provided a trust certification, which has a probate code associated with it, and it's got the statutory language of that probate code, that's fine. Some companies record them. Some companies don't. It doesn't change the legitimacy of the certification itself.
I think you've answered a lot of our questions. I mean, basically, it's kind of we ran through these questions pretty quickly. One of the questions I have too, maybe you can explain for the audience, is like a Hegstead petition. We can run in that a lot too, where
Someone's refinanced
their home,
they
take it out of the home, and they didn't realize it was out of the trust. And so now we're in this, we've got to get either back in the trust or a Hegstead petition.
Right. So that's the probate 850 code, which is Hegstead. Hegstead is case law out of San Mateo County. And if I remember correctly, Mr. Hegstead actually wasn't deceased. So he sued, and his case became case law, I believe in 1992. Don't quote me on that, but it's around that time. Prior to the Hegstead rule, if a property was supposed to be in a trust and was not put into the trust for whatever reason, many county assessors used to accept the full recording of the trust agreement itself with a legal description on it as the conveyance to the trust. They will not accept that anymore. They push for the Hegstead. So here's the thing. You mentioned refinances. Well, many lenders would not lend to a trust, so they'd make families pull it out of the trust, put it into them as individuals, do the refinance, and then the property should go back into the trust. Well, during the refi craze, people were just refining, upon refi. So it was in and out of the trust several times. The problem with that is that if it didn't make it back into the trust on that last try, and then the people passed away, well, let's say, again, back to you two, you're showing in title as husband and wife, didn't go back into the trust, you're both deceased, and then your kids go to sell the property. They're like, hey, it should be in a trust. Well, there's no one's able to enter into contract to sell. There's no operation to get them to sell. So when we establish this, we go, you need to talk to an attorney, do the Hegstead petition, which is a shortcut through probate, right? We know the property was intended to be in the trust itself. It's really many times it's a one and done visit. And many of the courts do it via Zoom now. So you don't even have to go to court, but the issue is getting the court date, right, to get it done. So could it be a one visit? Yeah, but what if you have to wait 6 months to get that court date? That becomes a problem in marketing the property. But back to the Hegstead itself, what it does is it establishes that the property was supposed to be in the trust. It establishes who's acting as the trustee or successor trustee of that trust today and who's authorized to then enter into contract and sell the property. So it is formulaic, but unfortunately, again, as a title officer and underwriter, I am the guy who has to break the news at the 11th hour as to how that happens.
So what happens if there's a pour over will stating that everything should be in the trust, and if it isn't in the trust as far as properties or, would that suffice for you as far as a title company?
No,
or do you still have to go
unfortunately, no. You still have to create the entity who's capable of marketing title, right? So even if they have a pour over will, there's nothing of record. Keep in mind, we deal with record matters, right? So chain of title, in and out, in and out, in and out. Uh-oh, they left it out. How do we get the proper entity capable of marketing title, right? You can't record the pour over will because it's not a conveyance. It's not acceptable as something that would work to convey title. We see historically some very interesting documents of record where people were attempting to do things, right? Their intention was to move title, but they used some weird thing. I saw recently an assignment of interest that they thought was working as conveyances. And I'm like, well, if that was their intent, why didn't they just use deeds or quitclaim deeds? And these were back in the 70s. Again, Santa Cruz County, they did some things weird there. And it was all amongst family members, right? And it was a large farm. It was actually a producing farm. and there were several kids, and they go, well, I'll just assign my interest to you between brothers and sisters and stuff like that. Well, everybody started dying. And I'm like, well, these weren't really conveyances. It didn't work that way, right? And the assessor didn't accept any of them over the years. So kind of back to your point in the original part of the conversation, we had like 15 different potential heirs, and everybody's pointing in all these different directions as to who has it. I'm like, who thinks they have it? And this person says, it's me. I said, great. It didn't trickle down that way, but we're not going to probate all these people back. That's several probates. So we're looking back at a quiet title action type of situation there. And of course, the value of the property supported the cost of a quiet title action itself.
I never thought about it, the assignment issue, because that's
crazy.
That's the whole different ballgame, right? That's a whole different.
Well, we have, I mean, not to go off script here, but I save certain documents. I had one where people will deed to a bogus trust, right? And they kind of make it up and they do a deed. And then we ask them for a copy of the trust. And they're like, I don't have a trust. And I had one that was called the Peter Parker and Ben Grimm Trust, all right, which are Marvel superhero characters, right? And I'm like, really? And you could tell it was typed on a typewriter, not even a word processor. And so, of course, we asked for a copy of the trust, and they're like, oh, no. I'm like, why did you do this? They were trying to basically avoid liens attaching to the property. So they created this ambiguously named trust. I'm like, of which you've now shoehorned into an entity who cannot deed out. It doesn't exist. Mm-hmm. There was no successor trustees because there was no trust. And I said, so what you thought you were avoiding, you now created a much deeper issue. So
that's crazy. And how do you get out of that again? Say just
well, they were still alive. Yeah, they did have to go to court and reestablish. They basically had to abolish the bogus trust document, revert title back. And of course, the liens they were trying to avoid absolutely attached. So they did nothing but create this smoke and mirrors that bit them in the end. Interesting.
People do some crazy things.
They do.
I think on the line of our business too, in the probate and trust niche that we're involved too, we just see a lot of fraud too. We see a lot of issues that come up, and obviously it's great to have support with Stewart Title and such as yourself. Yeah. So it's good to get that up to you and see if we can actually clarify the situation. It is fraud. So that's really good to have this kind of, I'm giving you praise of kind of
I appreciate that.
Yeah, kind of a safety net. So,
well, again, ad nauseum comes back to communication.
Yeah.
Right. And I do more than 100 presentations a year, whether it's Zoom or in person. And I've done a few podcasts. This has been the best one. Actually, so far, this has been fantastic. So I appreciate that. But it really just comes down to giving out a phone number for somebody to call. And so everybody gets my phone number. Everybody gets my email. And other underwriters at another company that I work for, who I won't mention, literally said, don't do that anymore. And I said, why? And they go, because they'll expect us to do it. I said, you should do this.
Yeah.
If we're going to be the cure to transactions, then people need to be able to communicate with us.
I'll be honest, I've never had such access. So it's really nice. I mean, usually we're at the escrow layer and we can't get above that.
Yeah.
Escrow officer layer.
Yeah.
Meaning
it's always filtered.
And you don't know who's up there, who's above that. So
Yeah.
it's kind of really nice to actually be able to.
It's the Wizard of Oz up there and he doesn't want to be seen. I want to, do we have time? Sure. I've got one more story for you. And this one should really hit home with people listening to this. And I'm seeing it more, and it really has to do with elder financial abuse, right? And so in my presentation or seminar for elder financial abuse, I kind of break down the key characters are the ones who are abusing elderly people, right? And generally, statistically, it's sons over daughters, right? Sons are 2 times more likely to do it than daughters. So they're number 1 and number 2. Number 3 becomes grandchildren. But the one that's really racing up the charts right now are caregivers, hired caregivers. And you're both nodding, right?
Well, we've kind of...
I've interviewed an estate planning attorney that basically just said the same exact thing that you're saying.
So the most egregious, the 2 most recent and egregious examples of this were, I got the call 2 days apart, and I thought it was the same story coming from different people calling me. It was so similar. And this is what happened. I got a call, and it was a real estate agent trying to sell a property. And the agent said, will you insure this? That's always a red flag to me, right? Because that tells me somebody else said no. So when I looked it up, and most people don't know
shopping escrow companies.
Shopping escrow companies. And in many cases, I can look up a chain of title and see how many companies have already touched it. And I saw that I was the 4th or 5th title company in line. So it rejected, rejected, rejected. Well, so I humored the agent and said, okay, let me check it out. I ran the property. And so I already knew in real time in the conversation what I was going to ask. I said, do you have a copy of the trust? Property's in a trust. They shot it over to me with an amendment to the trust and a newly executed power of attorney. So the amendment was brand new and the power of attorney was brand new. As I was reading through the trust, the successor trustees and the beneficiary of the trust were a son and daughter. So again, real time, as I'm on the conversation, I'm Googling them and I find the daughter lives in Arizona, son lives in Texas. I could also find their cell phone numbers. That's a bit scary that I can get that much information from Google, but digging in, you can find that. I said, okay. I said, you know what? I may be interested in insuring this. I said, but I need the children to participate. Well, guess who was in tow with the real estate agent?
The caretaker.
The caretaker. Caretaker goes ballistic. Oh no, they've been estranged for years. They haven't talked to him. They've been no help. They're horrible children, blah, 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 right? The amendment removed the children as successor trustees and put the caregiver in charge of the trust. And then the power of attorney was for everything else. And again, these were only recently executed. Now, I could also tell how old the homeowner was. He was in his mid-90s. I found out that he worked at Lockheed Martin in Sunnyvale, where he retired. I found his Facebook account. He talked about his children. So I put the agent on hold, and I made a call to both those cell phone numbers and left a message, and then came back again and said, again, I need the kids to participate. I said, if they participate, we're good to go. Just get back to me. Hung up the phone. I get a call from the daughter from Arizona. She thought I was a scammer. So I had to legitimize myself and then say, you need to check in with your dad. This is what's going on. Once we got through part of that conversation, I discovered that her son and daughter had hired that caregiver to take care of their father because they weren't able to be there. And immediately the caregiver had alienated them out of the picture. And I said, well, you need to jump on it because they're actively trying to sell the property, which was free and clear, worth north of $3 million. It was in Santa Clara County. I said, so that's where I left it. I went, here you go. You guys got to jump in on this. All right. I checked on that property 3 weeks later, just out of curiosity. It was moved to Southern California and it closed. All cash, 2.7 mil, under value.
Wow.
Okay, so what's the responsibility of that real estate
Question
agent?
for you is that the amendment to the trust, who did the amendment?
Well, it's fraudulent because the person was, the elderly man was incapacitated. He didn't have the competency to do it. For one, right, you could tell it was just typed up on a word processor and the notary was probably bogus. Right. So, you know.
Doesn't an attorney have to do an amendment or can it not? Does it matter?
No, I mean, so.
Kind of like a holographic will, if you write something up after, could possibly work.
Yeah.
Take precedence.
Well, it's kind of funny. So let's go back to legitimacy, right? We ask for a copy of a trust in any and all amendments made there too. And as we see consistency in these amendments, and then the last amendment is inconsistent with the rest. It's a wild twist from what the rest of these things stated, right? That's questionable because the person's getting older every time they do something. Right. So then I call back into question, hey, this doesn't make sense. I want their doctor to tell me what their capacity is.
Well, don't they have to have more than two now? I think it used to be two different physicians, but now I think there's four, or there has to be.
Well, and that's difficult, Jennifer. I mean, it's kind of funny, and this is going to sound glib. So you go see a podiatrist, right? Do you see two because you have 2 feet? No, right? So most people, elderly people, go see one doctor for their situation. If it's dementia, Alzheimer, or some sort of incapacity related thing, they're generally seeing the same doctor. So getting two doctors almost, and that's a legal thing, to counter-check each other, right? Attorneys are going to go, well, we know one doctor can be fudging, but two shouldn't. Correct. And then back to your point, 3 shouldn't, 4 shouldn't, right? So it's starting to become more complicated. So we have to look at these things based on the integrity of the transaction. The one I just told you about was obviously fraud, right?
So now can the children go back and contest that sale, and they have to, how does that work?
Great point, because those children should be attacking the title company who insured that transaction.
Well, and the real estate agent and the caretaker. It's now a multi.
Sure, the caretaker's gone. If they got the 2.7 mil, they're in the Bahamas, right? But the other part of this is that there was so many potential checks and balances there that showed that this was not a good transaction. And I'm going to give you a bit of a punchline. One of the title companies that rejected it in Northern California closed it in Southern California. Wow. They saw the same data I saw. They saw the same evidence I saw. Why would they close the transaction?
Are they getting a kickback too?
Maybe. Something's awry. But see, I told you there was 2 stories here, right? The second one, when I got the call, everything lined up exactly. It's in a trust. It's an elderly person, and a caregiver is involved with a recent amendment to the trust. The only change is when I was talking to the young gentleman who said, well, it started with a real estate agent who then pulled in the son of the owner of the property, and they were both in Santa Clara County. Absolutely strange. He's like, I talked to my dad on Wednesday, and he was fine, but it was weird. He goes, because every time I've talked to him, you could tell somebody's rushing him off the phone. And I said, well, who's rushing him off the phone? And he goes, I think it's the caregiver that we hired to take care of my dad. I said, okay, that doesn't sound good. What's the next thing? He goes, by Friday, my dad was dead. And I went, okay. I go, well, how old was your dad? Well, he was in his late 80s. Could that be true? Did he just pass away? Potentially. He goes, but the caregiver has been trying to get access to his body to be released from the coroner's office by Monday.
Wow. That sounds
strange. So if
so
that doesn't give you chills, there you go. And she wanted the body cremated right away and da-da-da-da-da-da. So did she, so you understand where I'm going with this, right?
Well, and some trusts that I have looked at. Yeah.
And she's trying to sell the property at the same time.
Yeah.
He's alive on Wednesday. He's dead by Friday. She's trying to recover his body by Monday and is already trying to list the property.
So in the trust, I've noticed some trusts that I've looked at, they will specifically state in there, like, we don't want an autopsy done. Mm-hmm. We don't want, so I mean, did the caretaker maybe know any of these things to try to, rush it out?
I don't know, but keeping in mind that the caretaker's goal is to liquidate the assets of the trust itself. They may not have even read the trust. They don't care. They just have access to an elderly person. A lot of the signatures that are attributed to the elderly person aren't theirs, because we look at signatures, and over years you can see the degradation of a signature, but there's still aspects of it that look right. And by the way, we're not forensic specialists by any means, but when suddenly you see a signature that seems to be very spry compared to the 4 before it, you're like, nah, something's up here. So, again, remember I said the last, my first 30 didn't prepare me for the last 10. The sad part about this is that it's a trend that won't go the other way. Mm-hmm. It's going to continue to go on and on and on, because as we age, we will live. Our bodies will probably go much longer. Our capacity probably will not. So,
well, and I work with a lot of different seniors, and I notice, like you say, a lot of their kids are moving out of state, especially out of California. Well, a lot of these elderly people, they're not leaving.
Right.
They're either in care homes, or they're not leaving their home because it's paid for and they don't want to move in with their children. Sure. Or there's so many different dynamics. But yeah, so caretakers are becoming more prominent. Most people that do still live here work full time. They have kids. They're in sports. So
it is.
I know it sounds sad, but they're not there to take care of.
Yeah, it's just it's the evolution of this generation. right? It's the way it went. And the one, it's really funny. I'll kind of leave you guys with this is that if the parents do leave the state and live with their children in Arizona or wherever, right? Anywhere outside the state of California, and the property's not in a trust, the logical thing for a child to do is probate their parent where they're residing. But other states don't have reciprocity through the probate process to probate property in California. They can't distribute it through those probate processes. So then, unfortunately, if I were to pass, and I'm in Arizona living with you guys, right? And the Arizona courts go, okay, you guys get the property in California. You go to sell it as an underwriter, I have to go time out ancillary probate in California to ratify the findings of Arizona or any other state for that matter. And then who wants to go through two probate processes, right? And again, the average time of a probate in California is 18 months. Mm-hmm. So you see the breakdown of this. So this is why I'm trying to get ahead of it. And I'm speaking to real estate agents as to, you guys are the eyes and ears where we used to be. We're removed now. Technology has taken us out of the picture. We're reactive rather than proactive. So to get ahead of these things, we rely on everybody who's speaking to the principles of a transaction and then validating who those people are and if they have the authority to do what they say they're going to do, and are they doing it for legitimate means as opposed to nefarious means. So scary stuff.
There's a lot going on.
I think I have one final question for you. Then we'll wrap it up. So thank you so much for coming. One of the things that we ran into when particularly this last transaction is where the administrator of the estate that's been appointed by the court set up a bank account prior to going into escrow, let's say, and she set it up in a specific manner that she thought was correct. Well, when the escrow company or escrow officer told her it needed to be set up in this particular manner, they fought with us and they did not agree. And ultimately, it had to be set up the way that the escrow officer had told her to set it up. So my point to this is how do bank accounts need to be set up before, once funds are going to be dispersed into the account, what type of account is needed for a probate account, trust account, those types of things. How do they need to read?
Yeah, that's a great question. You probably should really have an escrow operations manager answer that for you. I'll give you my take. And so when you're talking about a probate account, the probate case should always have an associated account to it. So if property is sold out of probate, the proceeds can go back into probate to be distributed under the terms of the probate by the administrator or executor, right? So keep in mind, remember, a trust is a probate done before you die, and a trust should have an associated bank account. So if you sell properties contained in the trust, it goes back to the trust account. The successor trustee then doles out the money in the terms of the trust. Probate, same thing, right? The will is then, we're assuming there's a will in this case, the will states that these three people get the proceeds from the trust. There should be a trust account already set up under that probate number, probably through the attorney. I don't believe the courts actually hold the trust account itself. Yeah, with the EIN number. Yeah, so it's pretty easy to then send the money back to that case. And the one you're talking about, which was, again, unusual, right? We had to make some concessions there. Timing, nature of the people involved, situation, but we knew that there was nothing squirrely or nefarious about this. It was just people set it up the way they thought they could, and that to force them to do things in another manner was going to be difficult, right? So yeah, but what's very interesting here in that case, there was a trust account for a minor, and then there was a guardianship for the two, and each one of those should have had a separate account, right? For the minors under the guardianship, to me, seems like it would have been just pretty much a normal savings account, right? Type of situation of which the guardian was in charge of and had access to for the benefit of those children. Well, and I think you and I had part of this conversation is that we can't hold people accountable post-closing. All we can do is fulfill the transaction as it's laid before us, right? So we have the bank account numbers. We wire to those three different, accounts for the benefit of all those minor children. that's about all we can do, right?
Okay.
So as long as those accounts are set up legitimately, it's a trust account or an account for these children where this person is the custodian or the guardian of, we fulfilled that to the best of our ability. What happens after that if they're going to go sideways and start taking that money out? Yeah. That's the way it is. Keep in mind, and I'll say this one last thing. Every policy that's issued by every title company in the state of California, right? So on the owner side of the fence, covers fraud, forgery, incapacity of seller, and voidability of contract. This is why we go through those steps, is to make sure we have a legitimate transaction. And everybody's like, wow, why are you digging into my life so much? It's because I'm ensuring somebody here that everything that you've done is now legitimate.
Yeah, because I think we speaking earlier in regards to another title company that I'd used prior that wasn't as thorough. And some of the things that were kind of being done were, I don't think they were like super illegal, but they just weren't on the up and up. And so, kind of looking at those types of things, I love the fact that Stewart Title actually digs into those parts of the lives and digs into is it a pain for us? Of course. Yeah. But I would rather know that things are done correctly and there's nothing that's ever going to come back. I'm not going to have to go to court 10 years later because I was the agent on a case that didn't, that wasn't like kind of the caregiver case. Yeah. I wouldn't want to do that.
We can't catch everything. And the ratio of title people to escrow people is about 10-1, right? And the only things that we can underwrite are things brought to our attention. It's not a proactive approach because it's impossible. The closing ratio industry-wide runs somewhere between like 55 and 60%, right? So, that's not a great ratio. So to do something proactively, I'd be doing a lot of work that would never come to fruition. As a matter of fact, we'd need a lot more title people to do it. So in these cases, back to what you're saying is that stuff does fall through the cracks. Title insurance companies pay out hundreds of millions of dollars a year in fraud and forgery and other issues. So do we catch it all? No. Are we trying? Best we can.
Yeah. Well, we really appreciate taking the time to come out and talk with us today and give us this information. It's huge and it's very helpful and hopefully it'll help someone that.
Oh, my pleasure. My pleasure. It's been great talking to you both.
Thank you, Scott, for coming today. We really appreciate it. And I think you've clarified and just, put a spotlight on certain things that we just needed clarification for ourselves.
Good.
So thank you so much.
You bet. Thank you.
Thank you for coming today.
You bet.